Okay, it's late at night, after 10 o'clock, so I gotta do it all myself. It's 11/14/18. The day before, I thought I was supposed to be in court, of course. My attorney, even though Thomas Althouse, okay? Another one of those jerks at the county public defenders who doesn't know the law or care. So I contacted Mr. Althouse. Mr. Althouse and responsible attorneys, why don't you tell me when I'm supposed to be in court? Is this not critical to my welfare, Mr. Althouse? Shit, he never contacted me with when I was supposed to be there. August 29th. Let me get the other glasses here. To be my attorney, in fact, I suggest you understand the bar rules, evidence rules, rules of the court, and your obligation to have only your client's best legal and personal interest in mind. Bar Rule 5110 and AB 1909 are to be immediately followed by you personally, since you have direct knowledge of these laws being broken on this innocent defendant from day one. Now in multiple cases, including the mental health court. Yeah. Do you know why they took me to the mental health court for the 4th time? Of course, that's quadruple jeopardy, illegal according to the U.S. Constitution. Of course, they couldn't care less. Because my stupid attorney, Sir Antonazzi, when you're out of law school, the idiot, in front of 6 sheriffs in the hall, with everybody watching this, with their supervisor there, denies that there's any evidence rules. And wait till I tell you later what I got from the DA's office and shit. And then we have this guy, Thomas Rodriguez, who's a sociopathic psychologist, paid $500 for a half an hour to find out if I know what a judge is, and determined I don't know what a judge is. And yet, guess what, people? Pretty soon on fraudbuster.org, you're going to be able to see my amicus brief to the California Supreme Court that helped win an important case for a teacher, huh? And I'm going to load up my audit by the state of California in 1997 of LAUSD. I'm the only person to ever have them audited. For falsely charging teachers with child abuse, for whistleblowing, and principal stealing student interest funds. Oh, did they do it? Yeah, they did. Go to George Bazzetti, YouTube, and George1LA and fraudbuster.org. And don't forget Section 271 of the 2009 LA City Charter, which states that it's illegal for the DA to prosecute any misdemeanor committed inside the city of LA. Okay? Of course, for 5 years I've been illegally prosecuted, and tomorrow we'll be facing a DA with the same Judge Longoria, Judge Roberto Longoria of Division 95D, okay, at 1925 South Hill Street, in their phony little place down there, had declared me competent in a nanosecond, and then I'm declared incompetent. Have you ever heard of such a thing? So, here we have something really interesting. Go to the LA Superior Court case summaries and enter these numbers: 7VW07565, 8CJ07937, 4EA06937. On here's the mental health court cases: ZM027084, ZM045322, and there's no match. I'm in court, but I don't exist in the system, huh? Oh, let's have some fun with this one before we get to this other stuff. I'm going to read you the letter sent by former Chief of LAPD Charlie Beck, May 16th, 2018. Approved by the entire upper echelon of LAPD for the last 2 years, which includes, guess who? The new chiefy. And because this goes way into the past, the present Sheriff of LA County, huh? Dear Mr. Bazzetti, an investigation into your complaint that was reported on November 7th, 2016, 2 years ago. They're required to give you a complaint number right away. They never gave you the complaint number till this letter. Regarding the conduct of employees of the LAPD has been completed, period. The investigation has gone through several levels of review, including myself and the command staff of the Internal Affairs Group, period. Your allegations that the department failed to implement the Internal Affairs Cooperative Agreement, I have to explain that for a second here. If you all remember the Rampart scandal, the feds filed in 2000, and then there's an agreement, a DOJ agreement in 2001, to prevent them from going to trial, right? Because it could get worse in trial. Included a section on internal affairs. You know when you turn on your TV every night and you hear about those people killed by police and they say it was in policy, right? And everybody gets madder than hell, okay? Well, damn, go read the agreement on Fraudbuster. Assisted it being written by Seattle, who killed the pregnant lady, remember that one? And guess what? According to the Guardian, it's been $1,100 per year. They took it from newspapers and stuff. Killed by police, in custody, and or on the streets. By the way, I have the latest quarterly report that I'm going to load up on the Sheriff's Department on how many they killed. Oh, yeah. And in 2000, Congress passed a law for police agencies across the U.S. to collect this information and give it to the DOJ to build a database on what's going on. Well, you know how crooked we all are through a lot of administrations. It doesn't matter whether it's Democrat or Republican, really. And I'm a Democrat, but I'm a true progressive liberal, not one of these fake ones like down here in this city here that are really Trumpsters, okay? And what has happened is, a large percentage of those 1,900 people a year, which equals about 27,800 in 15 years, or 6 per day, okay? That's what the number is. Let's say it's only half of them killed. Gee, that's only 14,000 illegal, illegitimate homicides by police, do you dig? Against a DOJ agreement. When I went to the mayors of 3 cities before their cities burned, and to the lawyers for those killed, they begged me for that DOJ agreement and stuff, and I sent it to them, and I watched their cities burn. This is pretty disgusting. Your allegations that the department failed to implement the Internal Affairs Agreement, that employees failed to take your complaint against LA School Police, for perjury, and LA Unified School District employees for perjury multiple times, as you could see at HCJ 07937, and for EA 0396937, which is double jeopardy, no exculpatory evidence against PC 1054, 851.5, AB 1328, AB 1909, and SB 355, and some other exculpatory evidence stuff I'm going to read to you later. That members of the LA's Police Board of Commissioners erased Police Commission meeting audio recordings from the LA City View website. Okay, go to fraudbuster.org, 5515 LAPD Police Commission meeting. I'm at minute 2317, okay? Go to Real Audio and listen to what I said so you can listen to on fake audio at the same point the LA City Council function of some kind, because we got it ID'd at minute 22:17 when you hear Mr. Cedillo, now Mr. Koretz, okay? Duh, I'm so stupid. And that unknown employees denied your right to make telephone calls while in police custody have been classified as non-disciplinary, no misconduct, period. This means that the acts alleged did not rise to the level of misconduct, and named employees' actions were protected by law or found to be consistent with department policy or procedure. Don't they just admit that they refused my 3 completed phone calls within 3 hours for 3 to 5 days, and in fact I never got out on my own PIN number both times they put me in that trash pit. Had to use other inmates' numbers and PIN numbers, ID and PIN numbers, okay? We got all the proof of this. With credit card bills. Now, I'm guaranteed to everyone, not just me, is guaranteed in California, 3 completed phone calls within 3 hours, according to the California Supreme Court decision, Carlo versus City of Chino. Now that we're going to prosecutors, I'm going to give you a good case law that somehow all these guys seem to miss. Federal U.S. Supreme Court decision, Kalina versus Fletcher. Guess what this guy says? If the prosecutor breaks your civil rights, they have no more absolute immunity. Oh, gee, do you know what that means, people? You can sue them, put them in prison and everything as long as they break your civil rights, like I'm going to explain to you that they did to me. And this is signed by Charlie Beck and Michael Hyams, Hyams, Commanding Officer of the Internal Affairs Group. AB 1909. This bill would make it a felony punishable by imprisonment for 16 months or 2 to 3 years for a prosecuting attorney to intentionally and in bad faith alter, modify, or withhold any physical matter, digital image, video recording, or relevant exculpatory information or material, knowing that it is relevant and material to the outcome of the case, with the specific intent that the physical matter, digital image, video recording, or relevant exculpatory material or information will be concealed, destroyed, or fraudulently represented as the original evidence upon a trial. And I've called for the judges do this so many times to make your head spin, and they don't give a shit. Okay? I was the last person to speak at the Federal Reserve Board on Mnuchin's One West CIT merger. This is directly from my statement to senators, U.S. senators, on the Treasury Department problem. Earlier in the day, about 1 p.m., a preacher and backer of the merger said, "At 4 p.m. today, the head of CIT will meet with us and give us another $400,000. I spent 6.5 hours on the phone to find out where the videos are supposed to be from their staff. The videos are missing. I do have the transcript. Oh, and don't forget, I organized stopping a $300 billion bond measure J in LA. That made a lot of people happy. And here's some fun. The FY 2018-19 recommended budget for the Board of Supervisors of LA County is a total of $30.8 billion. Sheila Kuehl said it's 32. She's only off $1.2 billion. Reflects a decrease of $800 million in total demand when compared to the previous year's budget. Well, guess what? That's how I got SEIU. $15 an hour, $8,300 per worker. And since they're presenting me for a year from going into business, and I just got a notice from the tax board that I haven't done anything, they're thinking about shutting down my account because of them. I'm going to be filing the Sherman Antitrust Act, Cartwright Act, and the Unfair Competition Law for injunctive relief and civil penalties. Gee, I'm going to copy everything that Kamala Harris used in a case. Does that sound like cool? California State Court rules that the NCAA show penalty constitutes an unlawful restraint under California law. That's restraint of trade. That's a good case decision for me again. Now we're going to go to the bar rules. But first there's a thing called effective assistance of counsel, right? The right to counsel is the right to effective assistance of counsel. From the beginning of cases, holding the counsel must be appointed for defendants unable to afford to retain a lawyer. The court has indicated that appointments might be made in a manner that affords effective aid in preparation and trial of the case. McMahon versus Richardson, Powell versus Alabama, Glasser versus U.S., Culver versus Sullivan, Holloway versus Arkansas, McMahon versus Richardson, and Strickland. Okay, that's just to start with that stuff. Now we're going to start with bar rules. This bar rule, including the judges, say doesn't exist, and they tell me to my face. So let me ask you this. How does California State Bar Rule 5-110, Special Responsibilities of a Prosecutor, exist? And you can look it up on the net. Approved by the Supreme Court effective November 2nd, 2017, okay? The prosecutor in a criminal case shall not institute or continue to prosecute a charge that a prosecutor knows is not supported by probable cause. Make reasonable efforts to assure the accused has been advised of the right to and procedure of obtaining counsel and has been given a reasonable opportunity to obtain counsel. Not seek to obtain from an unrepresented accused a waiver of important pretrial rights unless the tribunal has approved the appearance of an accused in propria persona. Make time for the disclosure to the events of all evidence or information known to the prosecutor knows or reasonably should know to negate the guilt of the accused, mitigate the offense, or mitigate the sentence except when the prosecutor is relieved of this responsibility by a protective order of the tribunal and exercise reasonable care to prevent persons under the supervision or direction of the prosecutor, including investigators, law enforcement personnel, employees, or other persons assisting or associated with a prosecutor in a criminal case from making an extrajudicial statement that the prosecutor will be prohibited from making under Rule 5-120. F. When a prosecutor knows of new credible material evidence creating a reasonable likelihood of the convicted defendant did not commit an offense of which the defendant was convicted, the prosecutor shall 1. Promptly disclose that evidence to an appropriate court or authority, and 2. If the conviction was obtained in the prosecutor's jurisdiction, promptly disclose that evidence to the defendant unless the court authorizes delay and undertake further investigation, make reasonable efforts to cause an investigation to determine whether the defendant was convicted of an offense the defendant did not commit. And that's right where I fit. Of course, they don't want to do that. Bar Rule 1.3 that they seem to not understand, that lawyers shall act with reasonable diligence and promptness in representing the client. Bar Rule 1.4, communications. The lawyer shall promptly inform the client of any decision or circumstance with respect to which the client's informed consent, as defined in Rule 1.0e, is required by these rules. Reasonably consult with the client about the means by which the client's objectives are to be accomplished. 3. Keep the client reasonably informed about the status of the matter. 4. Promptly comply with reasonable requests for information. And 5. Consult with the client about any relevant limitation like a lawyer's conduct when the lawyer knows that the client expects assistance not permitted by the rules of professional conduct of another lawyer. B5. A lawyer should explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. Every one of those rules breaking every time for 5 years by every one of these filthy public defenders in slap law. Repeated prosecutions for political reasons, people, with perjury. Special conflicts of interest for former and current government officials. That's kind of self-explanatory. Declining or terminating representation, that's Rule 1.16. The client insists on taking action that the lawyer considers repugnant or which the lawyer has a fundamental disagreement. Duh! I just want him to follow the law and he wants to break it. Conflict of interest, current clients. I mean, you know what conflict of interest is. Can't accept the appointment if it's going to result in a violation of the rules of professional conduct. Duh. And again, if I'm so repugnant are my issues, okay? So I'm obviously repugnant to the guy. After all, I'm only a 71-year-old civil rights leader, falsely prosecuted by these fools for 5 years now. So I will come and do exculpatory evidence. This stuff is always really fun. Oh, God, this is right off of the LADA's website. See that those convicted are appropriately punished, uh-huh. Oh, but guess what's on 1, 2, 3, 4, 5? On paragraph 5 from the district attorney's own bullshit is, have city prosecutors who handle misdemeanor crimes and municipal code violations that occur when their jurisdictions prosecute. DA can only prosecute felonies. They decide whether there's sufficient evidence to file criminal charges. Do they know what perjury is by their own people? And they have 300 sworn peace officers known as DA investigators. They spent a fortune to fuck me with perjured information from former FBI. They spent a fortune. Wait till you see this stuff when I load it up. To the Bureau of Investigation alone is the county's 4th largest law enforcement agency. They have more than 800 clerical staff to screw everything up, and they were formed February 27th, 1850. Oh, here we go. Special Directive 10-06 by Steve Cooley on the Brady Protocol, September 20th, 2010. On December 7th, 2022, this office issued a comprehensive Brady policy set forth in Special Directive 02-07 and Special Directive 02-08. This Special Directive supersedes Special Directive 02-08. This has to do with discovery obligations under Brady v. Maryland, 1963, 373 U.S. 83. What is required under Brady? Prosecutors are required to disclose to the defense evidence favorable to the defendant, which is either exculpatory or impeaching, as material to either guilt or punishment. Evidence is favorable to the defendant if it helps the defendant or hurts the prosecution. Sessunian and Strickler v. Green. The U.S. Supreme Court stated, in Brady, this court held that the suppression by the prosecution of evidence favorable to the accused upon request violates due process where the evidence is material either to guilt or punishment, irrespective of good faith or bad faith of the prosecution. We have since held that the duty to disclose such evidence is applicable even though there has been no request by the accused, U.S. Viewers v. Aguers, and that the duty encompasses impeachment evidence as well as exculpatory evidence, U.S. v. Bagley. Such evidence is material if there is a reasonable probability that the evidence had been disclosed to the defense, the result of the proceeding would have been different. Yeah. You know, these people can't follow the law. But that's not enough. No. Special Directive 13-01, Jackie Lacey, General Policy Requiring Disclosure of Exculpatory Information, June 4, 2013. Brady v. Maryland again. U.S. v. Augers again. Let's see, now I got... what is required under Penal Code Section 1054.1e? Et sec. Govern prosecution and defense discovery in criminal cases. That code provides that deputies shall disclose, shall means mandatory to defendant or his or her attorney, Any exculpatory evidence in the Deputy DA's possession or known to be in possession of investigating agencies. Any exculpatory evidence. Barnett versus Superior Court, People versus Bowles. And to be made 30 days before the trial. And don't forget Sassoonian and Strickler versus Green and Cowles versus Whitley and People versus Padilla. And don't forget to go to CalJack number 2.20 and CalCrim number 316. Oh, and here we got false report by prosecution witness, People versus Hayes. Pending criminal charges against a prosecution witness, People versus Coyer. Parole or probation status of the witness, Davis versus Alaska. Evidence contradicting a prosecutorial witness statements or reports, People versus Boyd. Evidence undermining a prosecution witness expertise. Inaccurate statements, People versus Garcia. Finding of misconduct by the Board of Civil Rights, we don't have that. Evidence that the witness has a reputation for untruthfulness, 3 Witkin Cal evidence, 4th ed. 2000, 288 to 290. Evidence the witness has a racial, religious, or personal bias against the defendant individually. Yep. Anthony. Promises, offers, or inducements to the witness include a granting of immunity, U.S. versus Bagley. Ooh, they got that. Gilgil versus U.S. Hey man, you know, this is getting pretty funky, isn't it? California makes it a felony for prosecutors to withhold or alter exculpatory evidence. Well, AB 1909 came about because of this murder down in Orange County, where the guy went into a parlor, a hairdressing parlor, and just blew 8 women away. It was really ugly. So Patty Lopez puts up a bill that makes it a felony to withhold the evidence. Of course they don't give a damn. And here I got a paper, Suppression of Exculpatory Evidence. Paper presentation by Gary A. Udishin, Sorrells, Udishin, and Anton out of Dallas, Texas. And suppression of exculpatory evidence. Brady versus Maryland. In Brady, the California Supreme Court, the Supreme Court of the U.S. stated, "We now hold that the suppression by the prosecution of evidence favorable to the accused upon request violates due process for the evidence of material." And well, we just had that one before too. And they got Rivera versus State, Giglo versus U.S., Cowles versus Whitley, Mooney, Pyle, Nephew. And this is only the first few pages of this. So here's the bottom line, people, why I'm doing this tonight. Oh, and I forgot this other little part. Right here. I'm 71, people. I lost 100 pounds on my own with no doctors or anything and gotten off of almost every drug when I've been ready to die. They expected me to die. And my health is so bad right now from being free and refused health care for 5 years by United Healthcare. Recently it's Humana. I went with Cedars-Sinai and they strapped me down with 10 pigs for a day and a half after they spent $38,000 to try to prove I was crazy, and because they were afraid I would have an embolism and die when they strapped me down. And now these pigs think that I don't have a mind. I don't even know what a judge is. Go watch me at the Board of Supervisors. I got 80 pages on Google or whatever. I earned it. Now they're doing this for political reasons because I got them caught with their hands in cookie jars and trillions of dollars. You see, they got a $30.8 billion budget, but they control trillions in bonds. Measure J stop was for $300 billion. That's 90 on the face, 300 with a payoff. Then they bring up Measure M that I got De Leon, Mendoza, and Ridley Thomason a problem with the morning they passed it at MTA. Fully sealed up with a text to Damian Goodman, who later sold me out. Yeah. See, I found a $10 billion overrun under the subway to the sea, verified by everybody too. So for the last 3 months, I went with Humana thinking that maybe they'll help me. Oh, we'll take care of you, man. So for 3 months, every day I'm on the phone for 2 to 3 hours, and I got gigabytes of recorded phone calls with these fools. To try to get a forensic psychiatrist, which I just had to pay $500 for Monday, Dr. Stephen Diamond, go look him up. He's one of the top guys in the country. I don't know what he's going to write, to tell you the truth. He did give me a letter to go to the court tomorrow. I should have had a continuance already. And this Althouse dude, this stupid public defender, Tom Althouse, hires a stupid, corrupt, perverse, sociopathic, another one after Thomas Rodriguez. You see, they're all contractors. They collect $250 for an half an hour instead of $250 in an hour at their shop. They got cards printed up to make them look like they're employees of the mental health division. No. And stupid McEnany, guess what the dumb woman does? They put the wrong email address on her business card that she hands out, yeah. I have proof they all kick back. I have Dupuytren's contracture in both hands. Go look it up. My hands are turning into claws. I get woken up at night with pain. They threw me to the state mental hospital and forced me onto Abilify, which at 71, elderly with major heart conditions and other internal conditions, it says right in the black box warning, can kill you with an embolism, stroke, and or heart attack, huh? Aren't these doctors wonderful? Oh, that's by accident, isn't it? And large doses of the shit. As soon as I got out of that pig pen after just 2 weeks on that crap, now every night I wake up with major pains about 3 o'clock in the morning in my right leg, feeling my bones want to blow out from the center. I really like these people, you know. So anyway, if I don't do another video tomorrow and post it to YouTube and Fraudbuster, you know that they're assassinating me. And not soft this time. They're going to do it hard. Just think of what happened to Whitey Bulger. Do you think they're going to let me go in there and come out alive again? After I was named OG of OGs in the Twin Towers for saving a man's life with them yelling at me to let him die, and a witness to the sheriff's killing 2 people in there, huh? That's already with the DOJ OIG. DOJ Central California, their own damn grand jury. How crazy are these people? We're going to find out tomorrow, aren't we? So you stupid fuck Althouse, and you filthy piece of crap Sarah Antonazi, and Susan Blossom, who's put in an appeal saying I would have improper without my signature and said I'm infirm. They call me gravely disabled, infirm, incompetent, psychotic, and every other damn thing in the book. And yet I make them shake down at the Board of Supervisors and City Council when I speak with my knowledge of all these issues and work with Sheriff Baca for 6 years on legislation. I got the proof of about 25 bills, huh? And I'm the master of school budgets and busting those fools too. Half of LA Unified's $27.5 billion went for nothing. So I got to go load this, and that's going to take some time, people, and get it loaded, posted up, because it's going to take time to load it in the computer, load it to YouTube, But then after that, it's easy to link it over to Fraudbuster. So I'm going to turn it off and go take care of the rest of this tonight. And hopefully, I'll be making another one tomorrow. And you can see what a trashy house we live in, huh? Isn't this just horrible? I mean, we just live in a horrible house because we're so messed up according to them. If you look up those terms, oh, look at these. They were only cast at 1780, and I got to show you something else. I know. George don't know how to do nothing. But I want to do this. Now watch real carefully as I tip it around. And notice that it's very dimensional, huh? Go on to your search engine and go look up 3-dimensional stained glass windows and see if there's any such thing. I guarantee you there is no such thing. I have videos of how I made it. It's very complicated. And go to fraudbuster.org and go to artwork and go see what a great artist I am. Or some people think so. Hope I talk to you tomorrow. Otherwise, you may never hear from me again.